Hey guys, Tony DeNaro here. Welcome back to the channel. Happy Friday, February 24th. There are some updates that I want to run through really quick with you on this video regarding Allegheny County versus AMC, this dispute over the preferred stock and the upcoming vote on March 14th, the conversion of the preferred stock into common and the reverse split. There was some court action on the 23rd. I've got the updates for you. Let's get right into it. The proceedings that you see on the screen here are from the Delaware Court of Chancery, which is the court where this case is being heard. The box that we're going to be looking at here is the one on the very bottom, the update from Thursday, February 23rd. There was a telephone conference on Thursday between the judge. Her name is Vice-Chancellor Morgan Zurn. I'll put her picture up here. Counsel for the plaintiffs was on the phone call, as well as counsel for the defense, which is AMC. I'm going to go through with you some of the details of what was said on that phone call between the judge and attorneys for both sides. Net result of the phone call, though, if you just want to skip everything else, is that there is going to be a hearing on March 10th between the counsel for plaintiff and defendant and the judge. So maybe we'll have some resolution by then. Maybe it will drag on. We'll know more on March 10th. In the meantime, counsel for both sides has agreed to meet and confer on discovery. And so that is what's going to be happening between now and March 10th. The updates that I'm going to be reading to you today are courtesy of the Chancery Daily, summarizing and analyzing corporate and commercial law in Delaware courts. And I'll put a link here on the screen for you if you want to go show them some support. Chance, the lawyer over at Chancery Daily, was giving us kind of a blow-by-blow as the conference call was happening. I'm going to go through some of these with you. He starts off by saying this kind of initial conference is fairly standard in an expedited TROMTE case, that is temporary restraining order or motion to enforce, where there are consolidation and other process issues to sort out, because Chambers does not do ex parte communications, but yet wants to be able to talk through the issues with the parties in real time, and obviously wants to do so on the record. Vice-Chancellor Zurn says that this will be strictly a scheduling conference. She says that there have been routine email communications with her chambers and just wants to use this conference for administrative purposes. 3 questions to answer: what type of hearing, when, and when leadership structure. Counsel responds that they have a leadership structure ready to go and hands off to Mark Lebovitz to address 220 board materials. 220 board materials refers to Section 220 in the Delaware law that gives the plaintiff the right to go look at the corporation's books. And he starts by discussing the fact that from the 220 request, they received documents that would go to the irreparable harm prong, step 1, and filing of a certificate of amendment which would alter the capital structure of the company, step 2. They want a SQO, status quo order, by March 14th or a TRO, temporary restraining order, so that the certificate could not be filed. The next update we have, the plaintiff's counsel is discussing the issue of when or whether to present how much of the substantive claim on the merits versus just presenting the TRO hearing in the first instance. Vice-Chancellor Zurn asked, what is your preference? Plaintiffs respond, we would present a TRO on March 8th if that's what's available. We would take whatever discovery is available to inform the hearing in theory at the March 8th hearing. Your Honor would either enjoin the vote or let the vote go forward. For the non-legal scholars watching, enjoin means to prevent something from happening or to issue an injunction to stop the vote. Now we have the defendant responding, the counsel for AMC. They have some issues with the leadership structure, it sounds like, due to the differing claims. It's unclear what he's saying about that. With respect to the timing, he first starts by saying the APEs were created in August 2022, the preferred series stock, and the first 220 demand made by the plaintiff to AMC was made in December, and the first proxy was made in January by AMC, and that the emergency then is the plaintiff's fault, not the defendant's. The defendant's preference is highly expedited discovery, obviously, because we have a vote on March 14th and a preliminary injunction presentation on March 10th at 1:30 p.m. if available. Alternatively, if the court can't accommodate that, is to have a hearing at some later date, permit the vote to go forward, but assuming a yes vote, not effectuate the vote, i.e. not file the amendment, to the certificate of incorporation until the court rules. But the preference is to have the preliminary injunction hearing on March 10th at 1:30 p.m. Next, the plaintiff requests to respond. Your Honor, two things in the response. The timing issue is not one of the plaintiff's making, he says. Not our fault. We didn't know about the timing on this. Not our fault. We didn't know about this since August. These securities, as set forth in the complaint, were issued with no indication or disclosure that they effectively, with one favored hedge fund, for lack of a better term, Antara, would be weaponized. Ooh. When we saw that they were being weaponized, we filed the 220. If the board was really doing a radical thing because there was a crisis, we thought we should know that before we filed. And you know, some of us have been pointing out that running low on cash, $500 million, could be considered a crisis, depending on what seat in the boardroom you have at AMC. Plaintiff goes on to say, we did not sit on our hands by any measure. We pled in our complaint that the vote is a fait accompli. I'm hearing Mr. Newworth say March 8th is not possible, but March 10th is possible. Our narrator goes on to say it's not clear what the plaintiff's lawyer is exactly arguing here, but it sounds sort of like, how are 2 days that much different? I think in the background, they were trying to decide on the court calendar what day was available. Defendant, counsel for AMC, wants to reply briefly on the merits, but mentions again that with respect to scheduling, the preliminary proxy was on file on January 27th, and the defendant thinks they can get this done by March 10th. They want to get this done. They say there is overhang. They don't mention the expiration of the deal with Antara. This is comments from our narrator. Vice-Chancellor Zurn has a proposal for the parties. Vice-Chancellor Zurn says that she hears the parties agreeing to an expansive and fulsome discovery protocol in 24 hours, as we mentioned back at the beginning of this video, that box at the bottom of the screen. If they can do that, she will set a preliminary injunction hearing for March 10th. If not, that will be a TRO hearing. She's basically calling the defendants to the carpet for their promise to do discovery in an expedited and fulsome manner. The protocol should be how discovery should take place, when, and from whom. And if they cannot agree to those things within 24 hours, that was by the end of the day today, then the March 10th hearing would be a TRO, not a preliminary injunction hearing. Zurn is presenting an excellent solution, the narrator goes on, and the parties are fighting about other things, really missing her point. Oh, that's what attorneys do, my friend. She'll find another later date. They are showing up on March 10th, no matter what. The judge is about fed up at this point. She says, okay, you can also have a later date for the preliminary injunction hearing. You can set that up with Chambers. That is all. 24 hours, guys, to get discovery plan in place. So bottom line, our narrator says we're having a hearing on March 10th. Depending on what happens in the next 24 hours and how well defendants can play with the plaintiffs in coming up with a discovery plan in good faith, it's either going to be for a temporary restraining order or a preliminary injunction on March 10th. That is the summary for what we have as of today, Friday, on the Allegheny County versus AMC. Chance, the lawyer, does have one comment here about the second case, Usvaldo Munoz versus AMC. He says, I've been reviewing the public versions of the AMC redacted confidential complaint and motion for SQO, or status quo order, or the TRO entered in the second case. They feel overly redacted, so there's not much for us to enjoy. But remember that the Vice Chancellor is not reading a redacted version. The judge has the full details. She has access to the information under seal, so it's important to always keep that in mind. We will keep track of that one as that case progresses as well and keep you updated here on the channel. I sure hope that if you didn't find this entertaining, you at least found it informative. Check back with me. I'll have more updates with you. If this is your first time here on the channel, please don't forget to buy and hold that subscribe button. Like the video, share it with your friends. I am Tony DeNaro, and I will see you on the next video.